This is Joseph Zodel. When is it appropriate for a judge to set the law aside? When the law is not sufficient. That is when the rule of equity is applied. That which ought to be done is that which shall be done. Of course, we want the law to be followed in the first place, but when does it not apply? Suppose a married couple with minor children both die at the same time with no will, like a fatal car accident. This is going to be messy no matter what. And just about everyone should have a will, so be sure to subscribe and click the notifications bell for a video coming up with practical information that you can apply for your own will. Well, the assets aren't really up in the air, as your state legislature has provided for the distribution if you die without a will. The law can't just simply let all the assets sit there indefinitely. After some time, a vacant house will be vandalized and so on. In the description below, I have the link to the Arizona statute as an example. If there aren't relatives as provided for in the statute, your assets all go to the state, which most people don't want. In this instance, in many states, the two children would inherit all the assets. But how will this be managed? Possibly the assets could be put into trust until the children reach legal age. But who will set up the trust and manage them? If there is no will, then there is no one designated as an executor of the will, in some states called an administrator or personal representative. So this is up to the probate court to decide. The two parents won't be there to say what they think should be done. More important are the children. Who gets custody? That is up to the family court to decide now. We do not have precise enough laws for the judge to go by. Example, there is no law governing if the parents both die at the same time, then the children go to the maternal grandparents if they are 10 and 12, but to the second cousin if they are 14 and 15. A will would solve this, but since there is none, and since the parents now cannot express their wishes, the court will resolve itself into a court of equity where that which ought to be done is that which shall be done. Who decides what ought to be done is the judge. This isn't a trial, so there's no jury. It's up to the judge. Many times the courtroom is filled with relatives who would like to take custody. Sometimes very loud arguments, and the judge will have to make the decision. Perhaps there are grandparents, but too elderly to care for young children. There is a brother who drinks too much, and so on. The judge may decide that none of the relatives are worthy of custody and send the children to foster care, to an orphanage, or some other remaining choice. It will be up to the judge to make the decision, as there are simply no laws that will directly apply. A classic example of equity is, when did Ohio become a state? Outside of viewers in Ohio, most people won't have the right answer. The traditional answer is 1803, when indeed a bill was passed by both houses of Congress and signed by President Jefferson with the intent of making the territory a state. But one of the requirements previously passed into law to become a state was that it was up to Congress to approve what the territory had proposed as its state constitution. This wasn't done. Time marches on. In 1953, the mistake was realized. Legally, Ohio was not yet a state, but really Ohio Territory, carved out of the Northwest Territories, and was still sitting there as a territory. Quick action was taken. In 1953, Congress passed legislation ratifying the state constitution retroactively, and it was signed by President Eisenhower. But can a state constitution that should have been ratified in 1803 be made effective for 150 years because of something done in 1953? No one wanted to argue against that. Over those 150 years, senators and representatives from Ohio voted on many measures. If Ohio wasn't a state during that time, they shouldn't have been in office and their vote shouldn't have counted. No one wanted to go back to examine every bill passed or defeated over all those years to determine in which votes the Ohio delegation made the difference between passage or defeat. Bills that would have to be passed all over again. Then there was the presidential election of 1876. Hayes won the presidency by one electoral vote over Tilden, 185 to 184. Now that was an interesting election because it was so close and 20 electoral votes were disputed. We'll be doing a video on this also. Ohio had cast its 22 undisputed electoral votes to Hayes. Take Ohio out of the picture, and we can see the election result of 163 for Hayes and 184 for Tilden. Should we rerun the election of 1876? How? The candidates are long dead. Was every bill signed by President Hayes of no effect, and therefore those bills never became law? Trying to deal with this would be trying to make sense out of a hopeless mess. So the rule of equity, that which ought to be done is that which shall be done. Ohio had acted like a state and been accepted as a state all these years, so we'll leave this alone and accept that everything that it did under its authority as if a state, and that its representatives in Washington did over 150 years, was valid. So equity is applied when the law doesn't cover a situation or where it is simply the more sensible way to achieve justice. Thank you for joining me today. If you found today's video interesting and informative, please give us a like, subscribe, and click the notifications bell so you don't miss out on the new videos we'll have coming up. In the meantime, here are some videos on this channel right now.